we're talking about algorithms. The term's been thrown around now as black box. And at the core of modern privacy law is a single goal. We need to make transparent the automated decisions that impact our lives. And that's the issue behind this. The core problem with algorithmic-based decision-making is a lack of accountability. Your machines have literally become black boxes. So I was trying to log into my VPN. And the problem is further exacerbated by the fact that people are just trusting these systems. They're trusting them because it's math. It must work. It must not have bias built into it. But people that are building the systems have bias, and the data that's going into these algorithms is biased. Algorithms are nothing without the data behind them. So we need to confront the reality that the power and authority are moving from human decision-making to machines. And that's why algorithmic transparency is a really core issue. And how are algorithms affecting our lives? Well, they can be used in hiring, they can be used in credit determinations, the news we read on Facebook, online advertising. Epic Advisory Board member Latanya Sweeney has done incredible work on this. She's a professor at Harvard. And a few years ago, a colleague walked into her office and needed one of her old papers. So she Googled her name. That's the easiest way to pull something up about you, right? Want to go through your documents, so you can just Google it. So she typed her name into the search engine, and up popped an ad on the right-hand side that said, Latanya Sweeney, arrested? And she was surprised, obviously. She'd never been arrested before, so she clicked on it, paid the fee to use the system, and found out that they didn't actually have an arrest warrant for her, so or arrest record for her. So curious, they put her colleague's name into the search engine, Adam Tanner, and an ad for the same company appeared, but no mention of an arrest record, just said, we have background information on Adam Tanner. So they did dozens more searches, and her colleague came to the conclusion immediately that ads mentioning an arrest record were much more likely to happen in searches with black-sounding names, as he put it, rather than white-sounding names. But Professor Sweeney, the distinguished data scientist that she is, said, I need to dig deeper into this, I need to study this scientifically. And so she did, and she found statistically significant discrimination in ad delivery based on searches, over 2,000 racially associated personal names across 2 search engines, and found that on the more ad-trafficked website, a black identifying name was 25% more likely to get an ad suggestive of an arrest record. And that can have a huge impact, because think about who's Googling your name. You're applying for a job, someone's Googling your name. You're going on a date, someone might Google you. College admissions officers, a bank determining whether to give you a mortgage. And the one that could probably cause you the most grief, like your mom Googling you, and I tried explaining algorithms to her. So these are big impacts on people's lives. This is an example of some of the searches she did. Another world where algorithms are being used, as Kade mentioned, are in the criminal justice system. And sometimes these are called risk assessments or evidence-based methods, and they're used to set bail or determine sentences. And they're really controversial because they're basically saying that they can predict future behavior for people that are going through the criminal justice system. Previously it was kind of judges that had that discretion and were using personalized information, which was also leading to bias, but it was transparent. These algorithms are not transparent. A 2016 investigation by ProPublica tested a system called Compass, and it's created by a for-profit company called Northpoint. And they found that the formula was particularly likely to flag black defendants as future criminals, labeling them almost twice, labeling them more likely to be future criminals twice the rate as white defendants. And not only did they find that, but they found they were also wildly unreliable. They were only predicting violent crime correctly about 20% of the time. And some of the ridiculous things that happen, like say someone who molested a child might be categorized as low risk because they had a job, whereas someone who had been arrested for public intoxication might be higher risk because they were homeless. So just the decision making made no sense. There was a case before the Supreme Court, and the Supreme Court was going to consider it, or was petitioned to consider it. Unfortunately, last week they denied the case. They're not going to hear it. But a defendant from Wisconsin came through the system and questioned why he couldn't have access to these risk assessment algorithms that were being used to make decisions against him. But unfortunately, the Supreme Court will not be hearing that case. Another algorithm in the criminal justice system are DNA forensics. So secret algorithms are being used basically to test DNA. There's a software problem called TrueAllel being used by law enforcement officials across the nation. And the individuals that this is being used against can't analyze the algorithm that is coming up with these DNA results. So in California, this meant there was a case named Martel Chubbs who was facing murder charges in a 1977 cold case in which the only evidence against him was a DNA match made by this software. And he asked to inspect the software's source code in order to challenge the accuracy of the results. And the court denied his request. Now, the court said, you can examine the state's witness, but you have no access to the code. Which brings me to what EPIC is doing about this. So we submitted FOIA, which are Freedom of Information Act requests, to 6 states to obtain the source code of TrueAllel. And we knew they were going to say, trade secret, you can't have it. But we wanted the states to say that they themselves do not have access to the source code. So these DA's offices, or the state police, are using these algorithms in court, testifying to their accuracy, and they don't have the source code. It's scary stuff. We're also, in EPIC v. DOJ, we filed a FOIA lawsuit against DOJ for information about the risk assessment tools I was talking about. DOJ has very conflicting statements. They have said that they're concerned over criminal justice algorithms, but then they recently said they want to build a system-wide framework, arrest through final disposition and discharge of evidence-based decision-making. So we said, look, significant interest in the release of these documents. We need to know what DOJ is planning to do. Have you tested any software? What's the future plan for use of these algorithms? So that case is pending. We only just filed it in March, and we will see where that goes. But there's a lot going on in this space, and EPIC is very active in it. Thanks.